Supplementary list. Pronouncement of judgment. Item number 1.
As can be seen from the earlier orders passed by this court had deemed fit and proper to provide a compensatory amount, taking into account the fact that had the petitioners rendered over the fact that the police had rendered over 36 years of service, and instructions had been sought as the amount agreeable to be paid by the respondent, which however was not received. In the circumstances, therefore, considering the fact that had the police continued to service from the date of disengagement till retirement, the amount of salary payable would be over 7 rupees lakh each, and considering the fact that they never served formal orders, they were never served with formal orders of disengagement, and also they had not rendered any service for this period, this court deems it fit and proper in the interest of justice and equity to direct the respondents to pay the purchase sum rupees 1 lakh each as a compensatory amount to bring a quietus to the matter. Yes. We have to accept that amount. Yes.
Item number 2.
Mazur.
Yes. The law of contempt is well settled. In order to hold a party guilty of civil contempt, disobedience must be willful, and the term willful connotes deliberate or intentional defiance. In the present case, the respondents had initiated the process of re-verification as directed and provided opportunity to the petitioner to present its case, which however could not be completed due to inability of the petitioner to provide the required documents and evidence. As such, cannot be held that respondents have willfully disobeyed the direction issued by this court. So contempt is dismissed.
Item number 3.
As such, the core issue in contention was for the jurisdiction of the MSERC to issue such orders, that is, tariff orders. The issue having decided and the same already been subject to the appeal, the question of review seeking clarification on ancillary matter, that's applicability of the tariff order dated 11/4/2003 to the mind of this court is not central or fundamental as to alter substantial findings of the order dated 2/6/2025. Further, an error to be apparent on the face of the record is as put, should be apparent and not to be ferreted out by examination of arguments or from a different standpoint that was not advanced categorically at the time of final arguments with petition. Furthermore, the entire judgment dated so and so currently subject matter, this review is dismissed.
Oblige.
Any mention?
Please, Your Lordship.
Yes.
My Lord, item number 36. With the consent of the petitioner, my Lord, counsel for the petitioner. My Lord, Mrs. Sen is arguing this matter. My Lord, the limited issue is Lordship has on the last occasion directed us to obtain one letter, my Lord, which reference has been made in one of the documents, my Lord. This with regard to letting of the land, my Lord, a plot of land to the cooperative bank
Yes.
for.
Yes.
So, my Lord, I'm just praying if Lordship can have this matter next week, my Lord. We have otherwise received, my Lord, just for confirmation of the letter, my Lord.
Yes, as per MS Arconi, allow to obtain further instructions. This matter next week. Yes, next week. Not after 2 weeks. Yes.
Please, Your Lordship, I'd like to mention item 26, Lordship. I've seek the...
Not prepared to this matter. We close it.
The problem is that the lower court matter is handled by Ms. P.S. Nongri, so I need her to be present also at the time of hearing.
You've been avoiding this matter studiously now for months.
No, last state, this state had to seek time. Just give us 2 weeks.
Okay, 2 weeks.
Raj.
Yes.
Your Lordship, I beg to mention item number 25. I prayed for 2 weeks' times.
Who's other side?
No objection, Your Lordship.
Yes. Yes.
Similar prayer for item number 34 and 38, Your Lordship.
No?
35?
34.
35, you're not there.
34.
34 and 35, you said.
34, 38.
Why taking wholesale adjournment?
Your Lordship, I'm there only for 38, Your
You
Lordship.
are objecting?
Only for 38, Your Lordship.
Objecting?
No, Your Lordship.
What about 34? Yeah, objection?
No objection.
Okay, yes. Yes.
Oblige, Lordship.
Please, Lordship.
I'd like to mention item number 35, Lordship, on behalf of Mr. Chanda. He's praying for 2 weeks' time, Lordship. Is currently unavailable.
No objection.
Okay, yes.
Oblige, Judge.
Your Lordship, I'm trying to mention item number 39, Your Lordship.
Yes. What's the matter? Hurt?
No, Your Lordship. It was not her.
What's wrong, Mr. Gautam? He is not well.
Yes, Your Lordship.
He's well, he's not well.
We need some more time, Your Lordship, in
Is
this
he
matter.
well or is he fit or he's not keeping well?
He is well, Your
Because he's
Lordship.
not been appearing in court. As court's concerned, he's well.
Yes, Your Lordship.
Very well, yes. 2 weeks, yes.
Oblige, Your Lordship.
Yes.
May I please, Your Lordship? I beg to mention item number 27, Lordship. Due to personal difficulties, Lordship, up to 1
Yes.
week, Lordship. Due to personal difficulties, Lordship.
No urgency.
No urgency.
No objection.
No objection. That's
Very
no
good.
urgency.
Yes. Yes.
Hello,
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 29.
Why mention 29?
Your Lordship, Mr. Sen has a medical emergency, so he cannot be here. Your Lordship, I'm praying
What is
for
there
a
in
week's
matter?
time.
You're for the petitioner? 29?
Lordship.
You're with whom? You are with
SD.
with SD with
SD.
he's a for the petitioner here.
No, Your Lordship. Mr. Paul is for the petitioner.
Where's the counsels for the petitioner?
29.
Lordship,
Yeah, objection.
Lordship, we had filed a contempt on this matter on the 16/07/2025, Lordship. We were praying if this matter may be listed on the same date. The main
What
matter.
contempt?
We have not received instructions. Has it been?
When's it listed?
Monday, Lordship.
It can
Monday?
come up Monday, yes, sir.
Okay.
Obliged, Lordship.
Obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 33.
I'm ending. Yes.
33. Joint request, ma'am.
20.
33. The rebel, shut up. 33.
What's the matter about?
Regarding appointment, Your Lordship.
You have objection?
No, Your Lordship.
No
Joint
objection.
prayer, ma'am. Joint prayer.
Okay. Yes. Yes.
Supplementaries. Item number 4.
May it please, Your Lordship.
Yes.
My Lord, a tender was floated by the Assam Rifle,
Yeah.
my Lord, on 8 May 2025 at,
Yes.
my Lord, page 15, my Lord,
Page.
1515, Annex
15.
2.
Yes.
Well, the tender was
Therefore,
for hiring of civil hire transport,
transport.
my Lord.
Yes.
So, my Lord, as for their tender, my Lord, the route was, the Lordship will find at page 16, the route and distance, serial number 5.
So how sound to Guwahati?
Yes, my Lord.
Yes.
My Lord. My Lord, in this RFP, my Lord, tender, if your Lordship comes to page 17,
Page.
page 1717,
Yes.
my Lord, subclause 7.
Yes. Details of vehicle.
Yes, my Lord. Details of vehicles on farm's name to the tune of the number of vehicles required in the contract duly countersigned by regional transport officer and district transport office along with one of the registration paper or vehicle or an undertaking obtained from concerned state, my lord. It is written as state, not states.
Yes, from concerned state.
My lord, this is the clause, my lord. Now, my lord, they have opened the technical bid on 12/7. Now they have disqualified me on the ground, saying that, my lord, lordship will see it at page 44. The reason which has been cited is the bid. Lordship had got page 44, annex of
that one line thing.
My lord, the bidder has submitted undertaking from association, union from Assam instead of Mizoram.
Yes.
From which tender are being called. Hence, the bidder declared technically invalid.
Yes. When's the last date for tender?
My lord, it was opened on 12th, my lord. So immediately after receiving this, my lord, we have filed a representation. Lordship will find it at page 45.
Yes.
In our representation, we have stated that such clause was never mentioned
in the tender document.
My lord. It has been arbitrarily passed, my lord. Just to favor the respondent number 4, private respondents, my lord. Now, my lord.
Private respondents there?
Yes, my lord. Private respondents.
You've already been awarded the contract?
No, my lord. I think not so. Now, what, my lord? Yesterday, my lord, they have issued me a so-called notice. I received it yesterday.
Let's see what so-called notice is. No, the tender says that only for a transport contract.
Yes, my lord. Now they have so-called me yesterday, my lord. I received it yesterday, saying that I have misdemeanor as my lord.
That is a different cause of action.
This is different. My rejection was different. Now they have come up with this story, my lord.
You're from Kolkata?
I am from Guwahati, my lord.
Then this is addressed to Kolkata.
The company is sorry, I thought this is from Kolkata, my lord. Yes, my lord. They said
CA, you breach the code by submitting a document which is fake.
Yes, my lord. Yes, that will answer, my lord. That will answer. We have
then this matter we can't take it up now. You have to address this matter first.
Yes, my lord. We'll address it, my lord. But the letter was issued by the joint secretary.
Doesn't matter. Yeah. See, we can't take auditions of it unless it comes. You have to file a fresh petition or take whatever steps necessary.
But they have given us 10 days time.
Your name?
My SP Das.
Mr. SP Das, heard legal counsel. Here must have legal counsel for the petitioner. Stop. Dr. N. Mozika, senior counsel, DSGI with so-and-so present on behalf of the respondents number
1 to 4.
1 to 4. Take down. No, 1 to 3, I think.
1 to 3 and 4, madam.
1 to 4.
4 also. 4.
Yes. The matter concerns the disqualification of the petitioner from a bid for providing transport services to the respondents on the route from so-and-so to so-and-so stop. However, after the petition had been filed, Mr. SP Das has submits that the petition has been served with a show cause notice dated 17 July 2025, which has changed the complexion of the matter. The same is produced and is perused according to the development. You list the matter for 2 weeks. You take whatever corrective steps.
Lordship may fix a time date, my lord.
Yes. List the matter for 2 weeks. Yes.
In the meantime, they will not open the financial bid.
No. Here, there's a different complexion altogether.
Well, he submitted a forged document, my lord, to establish his.
Passing the orders. Let him take whatever steps necessary.
We'll bring up this one. Obviously.
Yes.
How many copies you want? 2,000.
No, this one.
What is this, Mr. Deha?
My lord, here I am filing an application for modification and of the order dated 29th May, my lord, Annex 1.
Why? What modification do you want?
My lord, it's a status quo, my lord. What they have done...
It's in your favor?
No, my lord.
Then?
What they have done, they have put a lock above the lock of the petitioner, my lord. in the affidavit, my lord, they say that I have stated.
They put a lock over your lock,
My lord.
but it's other way around. They said that you have put a lock over their lock.
No, my lord.
Then?
They said that I have requested verbally to them to put the lock. If that is the stand taken in the affidavit in opposition. I have annexed para 17, my lord.
You didn't ask them to put the lock.
No, my lord.
The lock is yours. So they have put a lock over your lock.
Intentionally, my lord. Not to. That's why I am aggrieved by the status quo order, my lord.
Why you put the lock over the lock of the petitioner?
Before filing this petition, Your Lordship, in my affidavit it is clear.
Before you file a petition, you put the lock.
Yes, Your Lordship. So, Your Lordship, this matters already. I have,
the real matters get locked.
And moreover, Your Lordship, one suppression material fact, Your Lordship, this writ petition is filed. And in my affidavit, I have taken the.
You could remove the lock, move your lock. Because the intent of the order of the court is to be, he says that he's been wrongly
terminated, my lord.
Terminated from running his shop. Correct.
Lordship, in my.
But you never put that. You never put in the petition, Mr. Jha, that you locked the shop.
My lord, that
you
was.
Never said that in the petition.
My lord,
your prayer is only that I've been terminated.
My lord,
I should be allowed to run the shop.
Yes, my lord.
Then?
It was the prayer, my lord. That even my lord, why the petitioner will be before this honorable court if he has himself has requested them? The affidavit page annexed 2, my lord. Page para 17 can, my lord, can.
I can make it.
Annexed 2. I have annexed that, my lord.
How will we sit in that court? We'll see who put the lock on whose lock. Got a petition there. Affidavit. Where have they said that?
I have annexed in the miss case also, my lord.
Where in the affidavit, which paragraph?
Para 17, my lord.
17.
1-7, my lord.
Now he says that you request for.
They say that.
For a stated petitioner requested for safety and security of the goods inside the premises. Hence, authority has put their lock in addition to the lock.
My lord.
Then?
They say that verbally. If I have requested, my lord, now I am requesting them to take the out. There should not be any harm in the modification of this order, my lord.
Let the matter be finally disposed of, Your Lordship.
Now itself.
Let the matter to be finally be there.
Okay. You won't file reply to the miss case.
So Your Lordship.
Necessary. Take down miss case number. It was 1/2025. In WC number 189 of 2025. So, this is an application filed by the writ petitioner for alteration or modification the order dated 29/5/2025 passed by this court in the main writ petition. Stop. Mr. Jha submits that the modification is sought in view of the fact that the status quo order passed by this court has become futile inasmuch as the respondents have made it unable for the petitioner to open the shop as they put a lock over the petitioner's lock. So we therefore praise that appropriate orders be passed, directing the respondents to remove the lock. Yes. Stop, Mr. Adebnath. However, on behalf of the response submits that the matter may perhaps be disposed of finally on the next date. According to this matter, along with the miss case, next week. Yes. You come up with full instructions, whatever. Just find out whether.
Your Lordship, in this case, he is just misleading this honorable court, Your Lordship. Before this filing this writ petition, Your Lordship, when he issued the legal notice, we have given the reply of the legal notice. And
not there in the record.
In this legal notice, already in the reply, we have mentioned that's what the conditions thereof. Even we have mentioned that he has requested that he will vacate the premises, and he was asking the time.
Has he annexed the reply?
Yes.
Has he annexed the
reply to the legal
notice? Has he annexed it?
Yes.
My lord, that reply received after filing of the
You bring whatever you bring that.
My lord.
Your Lordship, prior to
Definitely, my
this, they didn't accept, and it is the record is here.
The court will examine whether termination is legal or not. That's all.
My lord.
If termination it's arbitrary, then we will interfere. Otherwise, not. Yes.
Daily list item number 1.
My lordship.
What's the matter?
So this is after the Supreme Court order, Your Lordship, there was the candidates who.
Yes. Why is it come today?
The last date, Your Lordship. Sorry.
Your Lordship, the main contacting counsel will appear through VC. Will argue the matter.
Yes. Who's the coming up?
The last date, we were ordered to supply the copies of my petition.
We receive, Your Lordship. Petition copies.
Yes. What's it for today? Yes. Please proceed. What is your prayer?
My main concern is, my lord, although my universities got dissolved through the order of the Honorable Supreme Court, my lord, but my concern is to validate my documents, because my lord, X of the students are suffering the same problem. Wherever they are going, any company, anywhere, so first of all, they are being grouped as a suspect, my lord. Because the documents are genuine. I completed my degree in 2012, my lord.
Yes.
In 2012, even the single allegation was not there on the university. I got my degree, I got the verification through RTA also, my lord. I have all the documents, I paid complete fees, my lord. But I am suffering only because the university got dissolved now, my lord.
Now, Mr. Verma, what impact does the Supreme Court order have on the proceedings here?
But only to dissolve the university.
Because otherwise I won't be able to take up this matter actually. Because I appeared for the state, I think, in the connected matter to Supreme Court.
Yes.
We have to list some other bench. Sorry. Yes.
Already the previous appeal from the university that was sent to another bench also.
Yes.
I have the knowledge about it.
Yes, list the matter before the bench which is taking up the other connected matter.
Item number 2.
Your Lordship.
Please, Your Lordship. Lordship, this matter pertains to the sale of land which I had purchased during the pendency of.
For my first thoughts, Lordship, if this matter may be adjourned for a week, Lordship, since Conduct Counsel Mr. Subhashish Sen is in his post today, Lordship.
It's just on the grounds of maintainability, Lordship. It's just on the grounds of maintainability.
Yes. Can be disposed of even without Mr. Sen.
Yes.
Yes, Your Lordship. Because they had challenged the maintainability of the whole case, Your Lordship, on the grounds of locus, whether I have locus to file this case or not.
What is the matter about?
So, Lordship, what happened is that this matter contains two aspects. There's a question of law and the question of facts as well. Now, the facts, Lordship, is that I had purchased a plot of land on 11/02/2024 from the respondent number 5, and that sale was executed via seal deed dated 11/02/2024. It was a kacha seal deed, Lordship. The seal deed is at page number 16 of my petition, Lordship, annexure number 1. The translated copy is at page number 17. So, Your Lordship, I had executed this sale deed for a consideration amount of money. And I purchased this plot of land on good faith, without knowing that there was pendency of litigation. Now, after some time,
the petitioner himself.
Yes, Your Lordship. I had purchased this plot of land from the respondent number 5, who is yet to make an appearance, Your Lordship.
Okay, you bought this property from number 5.
Yes, Your
What
Lordship.
happened after that?
So after that, I had bought this property on good faith, and without knowing anything, it was later revealed to me that this particular land was pending litigation before the district council courts at Nongpo. So what happened after that, Lordship? Because I had put a lot of money into it, and in order for me to protect my own interest, and the respondent number 5 had no means to pursue the matter. So in order for me to protect my interest, protect my investment, it was amicably decided that I was to be made the attorney holder of the respondent number 5, so as to enable me to pursue the matter in court as well, to finance the suit. Yes, Your Lordship. So that has been going on, Your Lordship. That has been going on. The trial in Nongpo has been going on, and I've been keeping tabs on it. But then at the end of the day, after some time, it was found out.
Funding the litigation for number 5.
Yes, Your Lordship, because I had to protect.
Bought the land from her.
I had to protect my interests, Your Lordship. I was left with no other alternative but to do that. So what happened after that, Lordship, is that there was talks that the land was to be acquired by the airport for the expansion of the Shillong airport. So I was called before the Deputy Commissioner, by the Office of the Deputy Commissioner, to have talks regarding that. Since the suit land is already in dispute, so I was called, and then there was no solution which could arise out of it. So they called the respondent number 5 as well. Respondent number 5, when that happened, she went behind my back. And then she revoked the power of attorney.
And then whom you sponsored.
Yes, Your Lordship.
Then?
So after that, Your Lordship, what had happened is that there were no ties anymore, and now I am left with no other remedy. Because why, Your Lordship? I had invested, and now my investment is gone. The land which I had bought as well. Yes, Your Lordship. Yes, Your Lordship. Now, why I've come before this writ court, Your Lordship, is simply on the prayer for reference, Your Lordship, because there is no other alternate remedy except for reference to the LA courts, Your Lordship. Why? Because
the money has already been released.
It is yet to be released.
Has already been calculated. Assessed.
Well, the facts are slightly different.
No, Your Lordship, the money has not been released.
So your case is that you had sponsored this litigation. You had bought the piece of land.
Yes, I had bought. So I
sponsored litigation, and where's that? And this respondent number 5 has revoked the power of attorney. And
yes,
taken the money.
Yes, Your Lordship.
Money's been taken also.
No, money has not been taken out, Your Lordship. Now the thing is that
then you file a suit.
Yes, Your Lordship. But
we can't in the writ proceeding we can't.
Yes, Your Lordship. My prayer is very simple, Your Lordship. Very limited as well, because I am only praying for reference, Your Lordship.
Prayer can be limited, but it can be innocuous also.
Yes, Your Lordship. Because
ramification.
My Lord, the prayer in the writ petition, my Lord. I'll just take a Lordship to the prayer.
Yeah.
Page 13, my Lord. A writ in the nature of mandamus or any other appropriate writ should not be issued directing the respondent number 3 to refer the reference petition of the petitioner dated 26/2/25 to the authority in accordance with section 64 of the right to fair compensation. Now, my Lord, the prayer is very innocuous, my Lord, but kindly come to the application, my Lord, which they filed before the collector. That is at page 42, my Lord. Page 42.
Before
the district collector, Your Lordship.
Which page?
Annexure 13, 42.
40.
42, sir. 42, Your Lordship.
Page 42.
Yes, Your Lordship.
Yes.
So, my Lord, this is a 26 February 25 to collector, my Lord.
Yes.
And seeking a reference that sees the owner. Now, my Lord, you coming to the facts. What is very glaring, my Lord? Lordship, the suit filed by at page 18 is the suit, my Lord, the copy of the plaintiff.
Yes.
This is the suit is between Viola, she is the mother, predecessor in interest of respondent number 5, my Lord.
Yes.
And between respondent number 7. I am representing respondent number 7. Suit is pending since 2002, my Lord.
You are Junior Ndathian.
My Lord.
Yes.
And my Lord, kindly see the prayer in the suit for a declaration that the suit land belongs to the plaintiff.
Yes.
So, my Lord, in one hand they file a suit for declaration that she is the plaintiff, my Lord, and on
that she is the owner.
And while the suit is still pending, my Lord,
the executes sale deed.
She executes a sale deed.
That
what is the value of that? That
is
kind
an
of sale deed,
admitted fact, Your Lordship.
Let me just complete. Yes. Just for 5 minutes, you can reply after that. So, when the suit is still pending, seeking declaration, my Lord, and during the pendency of the suit, she executes a sale deed, then she executes a power of attorney in her favor. Now, basically, if the petitioner has any claim, my Lord, that is vis-a-vis respondent number 5.
No, one thing, what stage is this suit right now?
Now, in between, my Lord, I filed my affidavit.
Has there been what?
The respondent number 7 and the respondent number 5 settled the matter outside the court, my Lord. That.
Where is that?
My Lord, kindly come to.
You file affidavit also? You already filed affidavit?
Yes, my Lord.
Oh.
Page 9 of my affidavit of respondent number 7.
Page
9.
9.
Annexure 4.
Yes. Annexure 4.
It's a stamp paper, annexure 4.
Why is annexure 4? It's the first annexure, correct?
Annexure A, sorry.
Annexure A. Yes.
Now, this is between Emma Gracie Taring, that's respondent number 5, and the professor Intathing is the headman of the village mallet, and the others are the relative of respondent number 7. Now they have finally settled the matter out of court.
Where's the defendant is whom in this agreement?
Malad, these people are the relatives, Malad, of Jinger Intathing, all this.
No, where is she in the agreement? She's dead.
She's very much alive, Your Lordship. It's just that the agreement was made outside of court. Yes, without.
No, I mean, where is that? If you see agreement between the plaintiff and the petitioner settlement.
Well, para 12, if I may just, Lordship attention, Malad. Page 12, Malad, third paragraph.
Yes.
Whereas it is acknowledged by the parties that Jinger Intathing, who was a party to the earlier dispute with so-and-so, and by extension now with Emma Gracie Taring, had previously conveyed portions of the disputable property certain relatives from the same Intathing clan, namely Professor Intathing, Birmond Intathing, and Byangmon Intathing. So now they have come to a settlement, Malad, all of them.
No, where's the name of the defendant?
At para 3.
The signatory. I think to this agreement.
But respondent number 7 is represented by these people, Malad. Professor, Birman, and Byangmon. They're the relatives.
We're not going to go disputed facts. Where's that plaint again? The plaint says Vela Taryang versus Jinger Rintathyang and Dran Sinteng Rintat Nongdhar. So where is two people Nongdhar and in the settlement deed?
Malad, Nongdhar is not, but Jinger is there, Malad.
Then what's happened to the suit?
It's still pending litigation.
So it is still pending. The suit will be disposed of, Malad.
Settlement was not filed.
You were in the process of filing with this.
Why don't you intervene there?
Your Lordship,
what kind of settlement is this also?
Exactly.
Malad, kindly see the problem, Malad. The land acquisition notification which they have annexed, Malad, you will also kindly see. It page 34 of the writ petition, Malad.
Who was shown as landowner there in notification?
The father of the respondent number 5, Lordship.
No bites number 5.
No bites square, Lordship.
Page 34, Lordship, kindly see.
Very vexed matter. 34.
Page 34.
Yes.
This is the land acquisition of 15 September 2010, Malad. This is what they have annexed, Malad.
You have the new notification now.
No, they are seeking reference of this, Malad.
No, it's the new notification now.
There ought to be a new
notification. We are not aware about that.
Has it already been taken over by the Airport Authority of India?
Well, this land has already been taken over long back, Malad.
Not yet, Lordship. Not yet, Lordship.
Take Mr. LCM, Learned Counsel, the petitioner. Also, Mr. Dr. N. Muzika, Learned Senior Counsel, on behalf of respondent number
7.
Number 7. And Mr. A.H. Kharvan Lang on behalf of the respondents 1 to 4. And none appears on behalf of respondent number 5. Stop. The grievance of the petitioner as projected is with the page number? Where's the prayer? 12. Okay. Yes, thank you. Is Sono? With the writ petitioner by institution seeks directions to issue the respondent number 3 to refer a reference petition dated 26/2/2025 filed by the writ petitioner to be taken up in accordance with section 64 of the right to fair compensation and transparency in land acquisition, rehabilitation and December 2013. Stop. Mr. L.C.M. Learned Counsel for the petitioner submits that the background facts are that the writ petitioner had bona fide purchase a plot of land, and from the respondent number 5
Yes, Your Lordship.
who has, in spite of service notice, not appeared, only to come to learn later that authority had purchased a plot of land, so and so. No? On 11/2/2024 from the respondent number 5. Bracket, who in spite of service has not entered appearance, and only thereafter came to learn of the pendency of a title suit with the vendor number 5 and a certain Srimati Jingeran Tathyang and Shri Dron Sinteng Nongdhar stop. The Learned Counsel submits that in order the writ petitioner thereafter supported the respondent number 5 in the suit by support the financially in the suit in the anticipation that in its conclusion the land has
I may submit, Your Lordship.
Yes?
I may just make a small submission, Your Lordship.
Yes?
Lordship, I am not before Your Lordship as an attorney holder, but I am actually before Your Lordship as the landowner, Your Lordship.
As landowner, we said that, yes, that, in anticipation that
yes, Your Lordship,
on the conclusion of proceedings, he would be
even after the execution of the seal, Your Lordship.
It is further submitted that to facilitate the conduct of litigation, the respondent number 5 had executed an instrument, had executed a power of attorney instrument in favor of the writ petitioner. However, he submits without the writ petitioner, without petitioner's knowledge, the said power of attorney instrument has been revoked.
Yes, Your Lordship.
And the parties, the respondent number 5 and other parties have reached a settlement which has left the writ petitioner without any remedy.
Yes, Your Lordship. As a matter of fact,
and remedy, and also made to suffer irreparable loss unless irreparable loss stop. He therefore submits that the acquisition proceedings for the said plot of land still being pending. His prayer at this stage is only that the entire dispute be referred to the reference court so that their respective rights can be adjudicated. Stop. Next paragraph. Dr. N. Muzika, who has entered, who is present on behalf of the respondents, who is Learned Senior Counsel for the respondent number
7.
7, Lordship.
7. Though a performer respondent has referred to the affidavit filed on behalf of the respondent 7 and submitted that the settlement has been arrived at between the respondent number 5 and the successors in interest of the respondent number 7, and that there at present there is no dispute, though the matter still is to arrange finality, still finality before the civil court. He further submits that the suit had been instituted as far back as in 2002, whereas the writ petitioner, by his own admission, by the Kacha
sale deed,
don't say by the unregistered sale deed, had allegedly purchased the plot of land only in February 2024. So, as such, he submits the writ petitioner having not acquired any rights, to the property, and no relief as claimed will be permissible. Stop. Next paragraph. Further counsel with the parties and also examined the materials as placed. Stop. At the outset, it is noted that the matter concerns disputed facts, and secondly, also the dispute, if still surviving, is purely civil in nature, and a suit is also pending before the
District Council Court at Nongpor.
courts at Nongpor. Stop. A perusal of a settlement deed which has been annexed to the affidavit also doesn't let the court to arrive at any conclusion with regard to finality or its purport thereof. Stop. Next paragraph. Next paragraph. Therefore, in consideration, in the facts and circumstances of the case and in considered view of this court, the matter that it petition will not be made tribunal as it is. The tribunal cannot be entertained as the same concerns disputed facts and civil proceedings as submitted are still subsisting. This is the matter, the same is not entertained and the petition is closed, leaving the petition to seek alternate civil remedy. Yes.
Right.
Item number 3.
May I please, Lordship? Lordship, I'll be filing the affidavit in cause of the day, Lordship.
What affidavit?
Lordship, the affidavit to the petition, Lordship, the detailed affidavit.
They've handed me over morning, my lord, so it will require some time.
In the morning to you.
Lordship, the affidavit
compensation regarding the death.
Lordship, Lordship, earlier did we have filed a short affidavit with regards to the amount which is the
ex gratia already been
ex gratia payment, Lordship.
Legally it matter.
Yes, Lordship.
No, what does the affidavit say? Prepared to give some more?
Lordship, replying to the...
No, replying, what is your stand?
They are making some avertment, they are challenging the maintainability, Lordship.
So, Lordship, if challenging the whole thing, Lordship, because we're saying that...
What do you mean the whole thing?
Lordship,
challenging the petition itself.
The petition, Lordship.
Why? On what account?
Lordship, since there are some, even the bills and everything which I have supplied...
He lost his legs and
yes, Lordship.
He lost all his limbs.
Yes. In fact, order dated 26/6/2023. This Honourable Court has made some observation. If Your Lordship peruse the order. Your Lordship, it's with regard to the...
Where is the order?
The order dated 26 June 2023, my lord.
Anyway, is not from the court. You filed it just now?
No, Lordship, I'm filing in the course of the day, Lordship.
Oh, you filed in the course of the day?
Yes, Lordship. I've just handed over the copy to the...
That the detailed affidavit being filed in the course of the day. This is matter after?
That comes
file, you examine it and...
yes, Lordship.
After 2 weeks to file a journal. See, if a person lost both his arms and legs, you questioning his duty execution, whoever may be at fault, I mean, it's...
Agree, Lordship.
Item number 4.
How much you paid? 1 lakh?
Lordship, ex gratia payment was paid... $1,50,000.
We only, I mean, with regard to the
hospital bill.
Yes, hospital bill that he has incurred, my lord.
Yes.
Item number 4.
Highly obliged.
Yes, MS Ibla. What do you want?
Please, Lordship. Respondent number 6, Lordship. The affidavit is ready, so we just need to get that signature. Just give us some more time.
Last time's matter came up on 27th of June.
27th. Yes.
Yes, Mr. Kharsar, you're not filing. Only 6.
Yes, Lordship.
You file in the course of the day.
No, Lordship. Next week, Lordship.
Yes. Mr. S. Markon, please sponsor further 1 week's time to file affidavit. Interim order shall continue.
Lordship.
Next year.
5.
Objection file.
Noted.
Objection filed to the application for review.
My lord, I'm not filing the objection. On the last occasion, my lord, we have to say that we will file it, but we are not filing. We'll argue the main case. Will not
the review be taken up?
No, because private respondent is there, my lord.
Delay application, my lord.
Have you filed objection?
Well, we leave it to your lordship because my lord, liberty is granted by the division bench. We leave it to your lordship to examine whether this.
Where's the PG Sama?
Uh,
He's on legs or he's somewhere else?
So went to school, Lordship.
Went to?
School, Lordship.
He went to school?
Yes. His son is getting related.
Oh. We'll have it next week then. Let it pass others in presence of this. As this case so and so, the counsel for the respondents, maybe Mr. SDEP and Mr. Sub, they submit that the question of condonation. What condonation? On request condonation, no objection will be filed. So leaving discretion of the court, yes. Just after 1 week.
Okay,
That is the piece of outcome.
I will Lordship.
Item number 6.
But I'm praying for some more time, my lord. I'll reply.
Yes, 2 weeks.
2 weeks time.
Alright, Mr. Mia, 2 weeks?
Okay.
Yes. Further 2 weeks as per allowed to the responsible affidavit.
God bless you.
7.
May it please your lordship. Your lordship, we just received the copy of the affidavit.
Well, today morning. What's the matter about?
With regard to promotion, your lordship.
Promotion,
5 and 6, I'm filing the prosecuted.
yes, affidavit on behalf of 1 to 4 has been filed. But the Musica correspondence number 5 and 6 submits that the affidavit on behalf of the said respondents will be filed in the course of the day. One list after
2 weeks.
join of any 2 weeks.
2 weeks.
Item number 8.
My lord, we have filed a rejoinder, my lord.
Yes, Mr. What is the matter about Mr. Na?
It's a matter of the land acquisition, my lord.
He also is appearing for the respondents.
One of the rejoinder is in reply to the MCS affidavit.
MCS.
Yes, my lord. That was the main.
What about this 6 and 8? What about the other affidavits?
Others have, my lord.
It will file.
No state has
What about 1 and 3, Mr. Dr.
not yet filed, my lord.
2, 4 and 5? You won't file rejoinder affidavit, Mr. Nad?
No, only this, my lord.
Only this. You won't file others?
No.
Yes, a rejoinder affidavit has since been filed to the affidavit filed by the respondents.
6 to 8.
Number 6 to 8. Stop. Mr. Nad first submits that no further rejoinder, no other rejoinder will be filed to the respondent. Calling this the matter of the hearing?
Yes, my lord.
On so and so.
Item number 9.
Same.
Highly obliged, my lord.
You filed rejoinder there also?
No, I don't know. Not.
Dear Muri, who is appearing here? Yes. Who's appearing for the respondents? For 1, 3 and 6 and a movement 2, 7 and 8.
2, 7 and 8 are appearing.
All affidavits are filed, man. Counter affidavits are filed.
Lordship, we have received the rejoinder only this.
That's all right. So you filed rejoinder to all affidavits.
Your Lordship, I filed the rejoinder only in.
To the state respondents.
Your Lordship.
What about union?
Your Lordship, the other affidavit, Your Lordship, the same issues are being discussed. Your Lordship will be relying on this affidavit.
Stop. But a rejoinder affidavit has been filed to the affidavit filed by the state respondents 2, 7 and 8. Stop. MSD Maori counsel for the petitioner submits that no rejoinder will be filed to the affidavit filed by the state as the issues are common.
Your Lordship.
Accordingly, this is matter for hearing.
Item number 10.
Yes, Your Lordship. Your Lordship, kindly allow me some more time to file my rejoinder.
How many times you prayed?
This was the second time, Your Lordship.
Second time? What's the matter about?
It's regarding forestry, Your Lordship.
They participated in a selection process. They were unsuccessful. They've come around and challenged the advertisement bullets.
Let them file rejoinder then. There's further 2 weeks as prayed for rejoinder activity.
Obliged, Your Lordship.
11.
Affidavit file.
Yes, Your Lordship.
You receive affidavit?
My lords, we have. Lords, we'll examine it and we'll file a short rejoinder.
Yes, Mr. Case Policy Council pays funds allowed. How much time?
2 weeks, my lords.
2 weeks time to file short rejoinder if necessary. Yes.
12.
In response to the application, in response to the miscellaneous application, not will kindly see my reply.
You got a copy, Mr. Paul?
My lords, we have.
Itself.
We've got it yesterday evening, my lords.
Yes.
May I pray, my lords, have this matter on Monday or Tuesday, subject to the lordship's convenience. We'll examine this reply, my lords.
Yes, reply has been filed by the state respondents. Yes, to the
you filed already.
To the miss case, being number 149, which is her name. Reply
I agree, my lords. Let the main petition be listed.
Petition on. We'll have it on. That's 23rd.
23rd.
Yes. So further orders. Give you enough time to go through it.
So we can make an effort to dispose of the matter, my lords.
13.
I'll pledge.
May it please Your Lordship. Your Lordship, you have already filed an affidavit.
Only file.
Praying for time to file my rejoinder, Your Lordship.
And for rejoinder, how much time?
2 weeks time, Your Lordship.
Mr. Pasantive, the constitutional praise funds allowed 2 weeks time to file rejoinder.
Obliged, Your Lordship.
14.
Prayer allowed, yes.
Lordship, as per the last order.
Where's Mr. Bora?
This one, Lord, is not available.
By order dated 36/2025, you supplied a copy of documents to him, correct?
Yes.
The pursuant to order dated 36/2025, Mr. K.B. Varashaji Leonard J. submits that a set of the papers showing the proceeding before the lower court of Nagpur had been supplied to the petitioner who was to take instructions. So, however, none appears on behalf of the petitioner today. This after 2 weeks. He'll come on his own whims and fancies.
15.
Should be pleadings are complete.
Rejoinder.
Pleadings are complete.
Any urgency?
Lordship, it can come after 2 weeks. Lordship has passed and now.
Body submit the things complete the matter for hearing on Thursday.
Obliged.
Obliged. 16.
Lord, we got a copy of the rejoin of the affidavit in opposition of the union government only day before yesterday, Lord. We need a little time to file a rejoinder too.
What's the matter about?
Well, regarding that, Your Lordship will recollect in the border areas, Lord, some cattle bears.
Sophisticated cattle rearing. Yes.
Some time to file it.
The ownership of the cattle have to establish, my lord. Who is the owner? I think that's the only dispute now.
Yes.
2 weeks time.
It's like, there was what happened many years ago, and there was some elephant, getting damage in the border areas. So then some EAC was deputed to conduct an inquiry. So when he was going about, then this fellow asked, inquiry, what will the elephant answer? He said. So I hope that's not the case. Yes, Mr. Estagoti, the Senior Counsel, pays funds allowed 1 week's time to examine the affidavit.
2 weeks.
2 weeks time filed by the.
Correspondent number 7.
You're the cattle owner also.
Respondent number 7.
This is the?
Respondent number 7.
Yes,
Sub-Inspector
whom?
Lordship. He's
Sub-Inspector Police.
He's addressed by name.
Oh yes, MS Ashwanta, MS EDC entered appearance on behalf of respondent number 7 today. So service is complete on all respondents. Service complete all respondents then.
Service complete.
Yes, please stop. Like Ms. Asori, please follow around 2 weeks time to examine the affidavit filed by the unions. Yes, thereafter.
All right.
17.
Mr. Tahir Dasis.
This is otherwise is a covered matter, my lord. Lots of early order. This is where betel nut was used along with the drugs, my lord. Now, betel nut, there is a final adjudication.
Where is Dasgupta?
Dasgupta is not well, Lordship.
Further off.
Next date, Lordship. It will be better.
Yes.
Next week.
Yes. Due to the, let's say that list the matter after 1 week, right, as the arguing counsel for the petitioners not present. Yes.
18.
My lord, service of notice is complete on the private respondent number 2 and 3.
Who's appearing?
None is appearing, my lord.
Where is that? Where is the factum of service?
It's on the record, on the last order, your lordship.
Oh, yes.
Record.
Come down record here. Come down recording. 2 and 3, no?
Yes, my lord.
Oh, yes. What is the choose a date? Come back in book. We can go be adhered to the first page. Also, this one. Yes, office note indicates that the respondents number 2 and 3 have been served, but however, till date, no appearance made on behalf. This transfer matter.
My lord.
Yes, as the matter is connected to, what is that one?
90 to 24. 90 to 24.
90 to 24. List together on the next date, yes.
Obliged.
Obliged, Lordship. I can have 6 of
6 Come here. 6 of this one. 6 to 10 subpoints. Nobody counsels.
Hearing. Supplementary list item number 6.
Only transfer matter, Mr. Archival General, what to do? How?
Now, if I submit the law, there are 2 things, Lord. So far as commercial judgment is concerned,
6 and all occurring matters. Please come forward. Commercial and these other occurring matters. Yes. Yes.
The commercial judgment has no bearing so far as the issue before your lordship is concerned. Because under the constitution and under the notification of the BNSS and CRTC law, powers have been conferred on the district and session judge to try the cases where the offence is more than 5 years. Even the conferment by the state government on KCDC code law, not in other narrow, there is no conferment. There is no conferment. The conferment is also not said that they have exclusive power to try the cases between 2 tribals where the offence is punishable with sentence of more than 5 years.
So are you, see, the only thing we have to be clear before we proceed to the matter is that, see, against commercial judgment, where they said that, okay, you know, where this division bench has held that jurisdiction is there with the regular courts under CRPC to try the matters, correct? Now that matter is going to appeal. Now suppose some other judgment comes out from there, and if we proceed to the matter now, if there is any conflict in the findings, won't it be? Okay, we'll hear you then. We'll hear you on one aspect only, because we've been just adjourning these matters.
Yes.
When Mr. Archival Data submits that in spite of the I took a commercial, give the site, just give the, in spite of judgment dated so and so, the division bench judgment. Well, no, the division bench judgment, Mr. Thaneso.
My lord, 17 to 2023.
Yes, just yeah. we'll record the submission so we can go proceed.
Yes.
Yes. Learned Advocate submits that in spite of Criminal Appeal number 1/2020, in spite of the judgment dated 17/2/2023, passed by the division bench of this court in Criminal Appeal number 1/2020 with Criminal MC number 2/2020 and Criminal MC number 3/2020 with regard to the jurisdiction of the district and sessions judge to take up criminal trials is been despite the pending consideration before the Supreme Court, the instant matters which are listed today, which are on the same issue, can be taken forward, as the issue of Supreme Court is only limited to the specific case of Omar Chang Singh Wanraya. Is that correct?
Limited
To the findings in the above noted cases. Stop next para. What about what do you have to say?
My lord, his submission may be recorded. He is saying that convergent judgment is not applicable in these cases. My lord.
I'm not saying
No, but he said that it's saying that for the findings are challenged. That's all. The findings of commercial case.
Regarding jurisdiction has been challenged by district council.
That the findings and that the instant matters pending before this court are independent of.
it can be decided
Can be said independently without awaiting the outcome from the Supreme Court. Stop. You agree or you disagree?
My lord.
You agree to take up matters?
Yes. We will cite the matter of the
Mr. Nongcloud,
interim order.
Mr. Mansuri and the other counsels appearing, the other committers have no objection to the submissions made by the Advocate General. Accordingly, we'll list the matter of concession after 2 weeks.
Yes.
Then you be prepared with your bullet points also.
Madam, it's a very important issue.
Item number 7.
Well, we have to distinguish also. That's the difficulty.
We will
It's a question of only applying common sense. It's a question of distinguishing whether the matter and can you produce a copy of the SLP also? That Advocate General requested. Yes, got to produce a copy of an SLP filed before the Supreme Court also.
I have annexed in my petition.
SLP?
Yes. That
Very
ordering.
Good. Not an order, SLP.
SLP.
Order is different. The order SLP is the meaning.
Yes.
Item number 7, supplementary list.
Yes, Mr. Padya. What to do with this matter?
Well, technically there is difficulty, my lord.
Technically and factually a different thing.
Yes, Lord.
Yeah.
Where the authority?
Lordship, I got only one.
Is it good authority or just
It may support my case, Lordship.
You give copy to
Yes, Lordship. I know.
Yes.
Para number 11, Lordship. Here, Lordship, the deceased husband of the petitioner during his lifetime had communicated to the department that I have married, my first wife had died.
That, see, Mr. Perez, remember whether the date of registration or can the and the assumption be made that the marriage is valid from the date of registration. That's the only thing, right, Dr. Mozika?
Yes.
Authority, we ask on that only. That if we can safely assume, without, touching other points, say assume that the date registration of marriage can be taken, for just for the purposes of this pension taken to be the date on which he married.
Since even that proposition in my humble submission, because the children are grown up from the second wife, my lord.
Yeah.
The grown up also.
They are grown up, and the daughter is married, and the son is also married.
17, if the marriage deemed to be 17, my lord, 2017. It's only 8 years, my lord.
That how to give relief to your court,
taking into consideration the date of marriage only, when they have
the fact remains is that your husband married you when the first marriage subsisting.
Yes.
Is there any other law that says that even if both the wives cohabit with one person, they'll be entitled to no? So that's what happened here.
Rule 50.
That is a submission that
54(7) is
after
also.
he was still married to her, he contracted second marriage, and they all lived together in the same place, right?
Same place, Lordship. Rule 54(7) of the CCS pension rule is when the pension is payable to more than one wife. That is also there.
Where?
54(7).
But you see,
this is cases
you are
where
in direct violation of the laid down law that says that you cannot contract a second marriage during subsistence of the marriage to.
Husband was liable to dismiss from service.
Yes, you're liable to dismiss from service.
They solemnize the marriage, but giving effect from the retrospective effect. That is the mistake that they have committed.
It's not that simple.
Mistake is the recognition of a fact, because if the children only grown up that time, or the registered subsequently.
Is there?
How to balance the equities?
That's pretty difficult in this case.
Now, what do you want to show from here?
From here only the rule 7A(1), where the family pension is payable to more widows than one. The family pension shall be paid to the widows in equal share.
There can be more widows than one only if they marry one after other, not the simultaneous.
Yes, many of the others we understand, yes.
So more than one widow will that situation will come when the first marriage.
More than one widow can be there, my lord.
One widow can be there, but the only problem in your case is that during the subsistence of your first marriage, you contracted a second marriage.
That is what the certificate speaks about.
Yes, certificate very clear.
Clear.
And it's registered marriage also.
That's why in Lokadalat also we asked, the daughters came, my lord. I was there in the Lokadalat. We said, you go to the registrar office, you can get it rectified. Department will not carry out any further.
Get rectified.
That is not possible. We have taken steps, Lordship.
Taken steps meaning?
For this rectification.
The officer said, my lord, if they can get it rectified, we will not conduct any further inquiry. The children are grown up or anything.
What to do? You can't find authority.
No, Lordship.
Impossible.
Impossible.
Only on the date of
yes.
Whether we can take it as the date of registration as effective date, notwithstanding any other circumstances. Dr. Mozika, when we take this date to be notwithstanding others, without looking at other circumstances, we take the date of marriage to be.
The certificate itself says with effect from 1981. Lord, so can you see the certificate?
Why is it like this? The said marriage this day has been registered under this act having with effect from April 10, 1981.
When get deleted, this part also, my lord, is okay.
You should have said that, okay, married earlier on but registered today.
Yes, Lordship.
Without giving effective date.
On this date, October 12, 27, full stop. That is enough for us.
What to do in this matter?
this can be treated as an exceptional case. Lordship.
We don't have power 142. No?
Only option it appears to me, my lord, that the department is asked to submit a representation.
Yes, Lordship, that will do. That we have, fresh representation will be submitted to the department.
Okay, take down.
But how far department can help, that was the question. At least they get time, then they can go back to the sub-registrar's office and try to rectify it something.
Yes, the writ petitioner is before this court with a prayer for release of family pension in her favor, for grant of family pension in her favor, with effect from the date of the demise of her late husband. Stop. The brief facts are that the petitioner's late husband he retired when?
1980.
11/1981.
Had retired from.
But I've given a note, the dates are there.
Yes. Oh, sorry, no, it's here, yes. Had taken voluntary retirement from service on 11/11/1990, and his first wife, one Srimati Amiya Roy, Amiya Roy, had passed away in 2009. And the deceased employee solemnized his second marriage on 12/10/2017. Stop. 2017. On the passing away of Shri Amarendra Roy, deceased employee, the employee of on passing away of the husband of the writ petitioner on 11/12/2019, the petitioner thereafter on 2024 had preferred a representation to the respondent for grant of family pension. But as it was recorded in the said marriage certificate that though that the marriage of the writ petitioner and the deceased husband, though solemnized on 12/10/2017, was with effect from 10/4/1981. The respondents had rejected the prayer of the writ petitioner. The rejection, it is noted, was due to the finding that second wife will not be entitled to family pension as a legally wedded wife, as the same was contracted when the first spouse was living. So, next, Mr. S. D. Upadhyay submits that what's the submission? That the case, that the instant matter is but a mercy petition. As the petitioner, how old is he now?
67 years.
Is 67 years old with no other means of sustenance. Stop. You have but the son is not supporting you.
The son is living with me, Lordship.
Son 28 years old.
No, so son is around 38 years now.
38 years now?
Yes, Lordship. His date of birth is yes, Lordship. His date of birth is
81.
81. No, 86. 9/7/1986, and daughter is 27/9/1992.
Well, they are soon due for pension also. Son, any problem? She's 67 years old now.
Yes.
Is presently 67 years old with no adequate financial means. So we just praise that the respondent directed to consider the case of the petitioner sympathetically, inasmuch as, notwithstanding other circumstances, the marriage was registered in 2017, whereas the first spouse had, whereas the petitioner's husband's first spouse had deceased as far back as in 2009. Stop. Next, for Dr. N. Mozikal DSGI submits that by application of the rules strictly, as though the marriage was solemnized in 2017, it being recorded therein that the same was to be effective from 1981 has prevented the respondents from taking any decision in the matter, and as such the petitioner till date has not been allowed or granted the final pension. This court has heard the counsel of parties and consideration of submissions made. It is submission made. It appears to be a case wherein by the technical application of by the strict application of provisions of law, perhaps the eligibility of the petitioner to final pension is highly questionable. Stop. A perusal of the certificate of marriage shows that the marriage was registered on October 12, 2017. However, is there any provision in law to say marriage effective from so and so?
Yes, Lordship. Yes. Yes.
But however, it is recorded therein that the same would be taken to be effective from April 10, 1981. In these circumstances, as no categorical orders can be passed by this court at this stage, in the interest of justice and equity, it is directed that the respondents consider the case of the petitioner sympathetically, especially taking into account the fact that the marriage was registered only in 2017. Yes, with the above noted observations and discussions, matter stands disposal. No direction. Yes, yes.
Age and this is without means.
Yes. And considering the advanced age of the petitioner. Yes. Next.
Item 28.
Lordship, here the case of the petitioner is for promotions. He's saying that he may be considered for the post of the headmaster in the Islamia secondary school. So his case is paragraph number 5, 6, 7, 8, 9. This is the paragraph, relevant paragraph which I have stated. How is entitled?
1 second.
Yeah. Paragraph number 5, paragraph number 5. How my petitions?
Para
number 5. It says, at the time of joining the post of the assistant teachers in Islamia secondary school, the petitioner was a graduate. Therefore, having a higher qualification during the service, and the petitioner acquired the higher qualification, that is B.Ed in 2012 and M.Com in 2013 to 2017.
You're serving as what now?
As an assistant teacher.
As teacher. Now you're saying that you're asking in terms of seniority.
Because there was a vacancy, there was post of the headmaster is vacant, lying vacant.
Still vacant now also?
Yes, still vacant. In this case, Lordship, the headmaster was...
From the beginning, lay down the background facts. What is
this is I am the assistant teachers. Why I am saying, Lordship, the case may be disposed of on the ground that the government filed an affidavit. The government says...
Where the government? Can you call him? The moment he appearing this matter?
What is his name? No, government is there.
Mr.
Karmi.
Call Mr. Karmi.
Government said it is solely on the managing committee to consider. In the government has got nothing to do. The managing committee and the managing committee by filing an affidavit says we haven't considered it because the representation is pending. And he's
consider his promotion.
So in this case,
let him finish.
No, you're appearing for the managing committee.
As a matter of fact, the petitioner has never approached the managing committee for promotion to the post of headmaster.
Straight to the court.
Straight to the court.
Here they have been in the para of...
Why, Mr. Kuruji, you come to the court?
No, that's what we say. Without going to the merit of the case,
why you come to the court? Why didn't you?
No, we filed a representation. The representation was not considered. They themselves are saying in para 4 that the managing committee was made for protection of his seniority, not for the promotion for the post of headmaster. The representation aforesaid has not been disposed of on account of the fact that he has filed the instant writ petitions and the result is awaited. There is a...
Your Lordship, Your Lordship, he filed a petition praying for protection of his seniority. It is annexure 6, page number 17. But he never prayed specifically for promotion to the post of headmaster. He straight away came to the
Then you withdraw and file representation.
No, that's what the representation already pending.
No, you withdraw this petition. No, it doesn't address your representation you filed earlier. Only talks about your protection.
No, I'll just read the...
Just your representation.
What are the points raised?
Where have you annexed it?
Representation is already annexed here.
Where? Which annexure?
Representation is annexure 6.
Page
17. 17.
That's all.
That's what only.
Where is I want to be headmaster? There's a whisper of a headmaster business here.
No, nothing here.
Then?
To Lordship, in this case, I just read the para number 4 of the...
I'm not going to...
managing committee.
You're going to basic your representation.
We have filed a representation. I am appointed as a temporary assistant headmaster. This is given the facts. And the school managing committee superseded 2 assistant teacher.
So?
Since so and so.
Where's your prayer petition?
I'm going to retire early. My academic qualification this much. I hope justice...
Your prayer and representation are like north and south. See your prayer.
In this case, Archival filed by representation. That is the...
Mr. M.F. Kurishi, the Council of Petition submits that as his grievance has not been correctly portrayed in the representation pending before the respondent number.
Managing committee.
Number?
Respondent number 4.
Number 4.
They bypass...
Mr. D.K. Datta. He prays a lot to withdraw the petition to prefer complete representation, detailed representation.
Direction may be given to me to file a report.
This direction has been passed, or this liberty has been allowed in view of the submissions made by Mr. Gididatta, that at no point of time has the petitioner ever represented
the same
to the managing committee.
Yes, to seek any recommendation or consideration to be for the post of headmaster. So, this is the matter. The representation stands close, allowing the petitioner liberty to approach the
managing committee to file a representation
and who also, on receipt of the same, shall dispose of the same expeditiously.
Yes,
obliged. See your prayer receipt representation, Mr.
Yes,
Qureshi.
I've seen the representation.
Why prepare Mr. Coach petition?
Item 30.
Mr. Qureshi is teaching you nicely. That means.
No, it is client done by himself only.
The client prepare himself.
This representation.
I wish we had clients like that before when we were practicing also. Okay. Prepare petitions. Yes. When was it gone? Last approval given to the school?
The approval.
Yeah, approval my lord, the copy.
Where was Hassan? Where was Hassan? None appears as a petitioner. Forget it, Mr. Take it back.
Yes.
Just after 1 week. Yes.
Obliged.
I'm not going to wait for.
31.
Another customer is clubbed together.
Obliged.
32.
Same.
Who's appearing here? Yes, MS Emercham.
Your Lordship, DSG is coming.
Lord, kindly have the order 2nd of April 2025. Lord, the matter was heard at length, and this was what was submitted by the respondent, Lord.
2nd of?
2nd of April 2025.
Yes, Dr. Mozika, what happened to this? Why did matter appear earlier on?
Pursuant to this, my lord, they've sought 3 times, my lord, for time, seeking for, my lord,
he was not present.
For instructions.
My lord, here what happened, my lord? I'll just point out few things, because basically there are grievances, my lord, that after recruitment, my lord, when he reported at the training school, he was subjected to medical examination, my lord, and he was found suffering from hypertension. Then thereafter, he was kept under ambulatory blood pressure monitoring system. Then his blood pressure was monitored for 39 days, my lord. I'll just take a lordship to my affidavit.
No, there's a final medical report. We had gone through all this.
Yes.
We had gone through all this, Dr. Mozika. Only thing is that, only thing what this court noticed.
At page 12, my lord, of the affidavit, the last line.
Notice that, where's that order just now? Notice that final report is not present.
Of the medical report, of the medical board.
The final report was not present in the records.
This order. Your lordships kindly have the affidavit filed by the respondent. It is in their report itself which the specialist concerned had given his opinion. If your lordships kindly have an extra one at page 11. This is the affidavit filed by the respondent.
Yes.
Now, if your lordships kindly come to the end at page 12.
Yes.
Para number 8, my lord. Opinion.
Yes.
competent authority may assemble medical board as per existing policy.
For further disposal.
Yes.
You didn't ask for instructions.
I asked for instruction, but the instruction is some. The instruction that I have. Just a minute. This is good.
So you conduct a review. You only have the instructions.
But
see,
there are 5 minutes.
Mr.
They still want to review.
No, there's no report of the medical. The board was.
No, see, the thing is that specialist opinion was sought.
Yes.
With respect to the comments, you know.
Yes, madam.
This is what's given in your page 12.
Yes, madam. Based on this, my lord, he was discharged from service.
No, that's what. But then the medical board is never constituted.
Never. It was not constituted.
After that. That's why they have given this instruction. How old is he now?
20, 21.
That's fine then. He can still go for review medical board.
Yes.
Pursuant to the orders of this court, seeking instructions as to the final opinion of the medical board on the physical condition of the writ petitioner, Dr. N. Buzika has furnished instructions as received, dated 13 June 2025. Stop. As per the written instructions, it is given that the respondents will accept directions to direct for the conducting of revenue medical board to ascertain the health condition of the petitioner. You don't object to this, Mr. Nongri?
No, my lord.
Mr. Nongri, the counsel for the petitioner, also object to this instruction as received. Next paragraph. Before passing final orders, this court is of the view that before passing final orders, this court.
The matter can be disposed of, madam.
Don't need to give instructions, yes. So next one. Accordingly, in view of the instructions and the acceptance of respondents to conduct a review medical board of this matter is disposed of by directing the respondents to, within what time?
1 month.
To conduct the
review medical
board within a period of 1 month, and to generate a report. Matter of instance disposed at this stage. At the stage itself. Stop.
37.
We do know that instructions were there in the file.
I didn't read that particular paragraph. I'm sorry.
Yes.
Instead of 30 days or 45 days, instead of 30 days or 45 days time, I do not know exactly. The time period is 30 days given, well, it's 45 days for the review medical board. 45 days.
You just informed them 45 days. Within 45 days, yes. Yes.
Your Lordship, the counsel for the petitioner is not keeping well, so it is not a count on. SS Oja.
It's from outside.
From outside.
What's the matter about?
This is regarding the this petitioner who's engaged in bringing vehicle from outside and registering in our
Oh
state.
yes, it's the old matter.
Your Honor, my lord, there are FIRs which have been filed in other state. There are allegations that stolen
You're
vehicles.
the only local council. Then yes,
If we can bring this on record, the copy of the FIR.
First, the report is supported by MS Hasindi that the Raging Council is indisposed. Assembly, sorry, the Council is indisposed. As such, let this matter stand over for
1 week.
1 week. Stop. Next, but however, Mr. N. Sunkan, however, has submitted that there are certain materials which need to be brought on record for proper adjudication matter, such as FIRs you can file against the red petitioner.
Yes, my lord.
Against red petitioner. So he prays for permitted to bring the same on record by way of affidavit before the next date. This is after 2 weeks.
My lord. Obliged.